So we're going to jump back into Richard Morgan Casey's testimony to the Post Office Horizon IT inquiry and questions from some of the core participants, so solicitors representing some of the sub-postmasters. And it's revealed by Sam Stein that the Post Office's cases were fatally undermined in 2013 when another barrister turned around and said, "You cannot use Gareth Jenkins anymore. You shouldn't proceed with any evidence from him. You shouldn't ask him for any more. He is not credible." It's hard to think it could have been put in stronger terms. And then he's subsequently accused of bias when he's again repeatedly taken to evidence in the court transcript showing that Lee Castleton did indeed numerously, consistently and repeatedly question the accuracy of the Horizon system, the integrity of the Horizon system and the illusory losses that the Horizon system was creating. And Richard Morgan seems to be struggling to find some answers. Let's jump into the inquiry.
We start with the date.
Yep.
There's a reference to that in March 2014. So working on that as being at least some contact to you, what I'm going to ask is, and see if I can find out whether particular points may have been raised with you that actually might stand out, might be important. I'm going to take you to a document which I provided to our document provider, and it is POL, P-O-L, 4-0-6798. And frankly, if you can go to page 13, internal pagination in the document, page 13. Now, this document is written by a barrister called Simon Clark, and it is dated the 15th of July 2013. Okay?
Mm-hmm.
Now, you can take that for me, or I can take you to page 14 where it has that at the end. All right. Now, at paragraph 38, page 13, internally within it, there's a reference there to Mr. Jenkins. Okay?
Mm-hmm.
Now, this is a reference to the Fujitsu.
Was he a doctor? Didn't know that. Like, obviously not a medical doctor, but I'm guessing a doctor of engineering or computer science or something. Because it's not a typo, because it's everywhere.
Employee who you had some reference to already in your evidence, and going back in time to Mr. Castleton's case, had some involvement in the Castleton case. Okay?
Don't recall him.
Well, you've just been asked a number of questions about Mr. Jenkins, the Fujitsu expert who you were saying could not be used as an independent expert.
Oh, that's Gareth Jenkins.
Yes.
Ah. Right, okay.
Right. So we're talking about the same person.
Okay.
Okay. Now, in this advice, Mr. Clark, who is a barrister working at a firm called Cartwright King, is setting out particular views that he's come to with dealings with this Mr. Jenkins. Now, you'll see there, paragraph 38, second of the two, if I call them bullet points, second of the 2 points. Accordingly, Dr. Jenkins's credibility as an expert witness is fatally undermined. He should not be asked to provide expert evidence in any current or future prosecution. Okay? So the date of this opinion being given, 15th of July 2013. And it's quite a serious opinion being given of someone in Mr. Jenkins's position, an employee with strong knowledge about the Fujitsu Horizon system. Okay?
It's hard to think of a barrister being able to put it in any more damning terms, or anybody, to be honest. His credibility as an expert witness is fatally undermined, and he shouldn't be asked to provide any more evidence.
Now, you mentioned in your evidence earlier on that you're not a criminal practitioner, but you are certainly a civil practitioner.
Yes.
And you're certainly a civil practitioner who's had dealings with, at least we know, the Castleton case you've been talking about, and we know also that the Post Office came back to you at an earlier point in 2012.
Yes.
Okay. So by the time we get to 20th of March 2014, this opinion is being given within, if you like, the Post Office by a legal advisor to the Post Office. Now, were you told, Mr. Morgan, that there was a settled and serious opinion given about Mr. Jenkins, the Fujitsu expert, who had a lot of knowledge about the Horizon system?
No.
I
can make it completely clear that I received no instructions, I received no papers. I did receive 2 or 3 telephone calls, however many were recorded in the in my evidence, which I only recall because I checked them against my computer system in Chambers. And I was only asked questions. I had no information tendered to me. There was not a, here's some further information, provide some more advice. It's, if we ask you this, what would you say?
Two last questions.
Of course.
Now, you and I had a number of questions, and you answered a number of questions when I first started a couple of minutes ago. And I was asking you about what you recalled about this meeting, and frankly, you're saying, really, I don't recall very much.
Yeah.
If you'd have been told at around this time in 2014 that regarding Mr. Jenkins, we got real doubt about this guy, I mean, I don't know what would be the succinct way you would put it, Mr. Morgan, but there's a real problem here. That might be quite memorable. Do you agree?
If I'd been told that, yes.
Second question, did the Post Office ever come back to you as a senior civil practitioner with at least some knowledge of these systems and say, look, we've got this problem with this Fujitsu expert. What would that have done to all of our civil cases that we've dealt with going back in time? Did anybody come back to you and ask that question?
No.
Give me one moment.
Sure.
I'm guessing even if it did cross the mind, they wouldn't have wanted to know the answer. It would be interesting to hear Richard Morgan answer that hypothetical question if he had been told.
Thank you, Mr. Morgan.
Thank you.
Who's next?
Sir, I am. Henry.
Over to you, Mr. Henry.
Thank you, sir. Mr. Morgan, as a contentious chancery and insolvency practitioner, you will be familiar with the case of Gessmin and Credit Suisse, won't you?
No.
Surely you must be. The judgment of Mr. Justice Leggett, where he was discussing memory.
Oh, yes.
Yes,
Yes.
thank you. And you will remember that
Sorry,
in
that wasn't
that
intended as a joke.
Sorry?
That wasn't intended as a joke, although it might have appeared as much.
Yeah, well, no, quite. You will remember that in the course of that judgment, he said that civil litigation, particularly in the preparation of witness statements, gives rise to powerful biases. You remember that?
Let me also be perfectly honest. I do very, very few witness actions. So although I am familiar with the judgment and I'm familiar with the overall thrust of it, I do not have specific passages in mind, but I'm quite content to accept that the preparation of witness statements is something that can give rise to evidence being fluffed, if I can put it like that, evidence being improved that shouldn't be improved.
I mean, is that just a nice way, if we're talking about improving evidence, of kind of embellishing it or maybe making false statements? Is that just a nice way of saying that?
Now, I don't suggest that of you, Mr. Morgan, but I do suggest that you have fallen victim to powerful and distorting biases. Let me explain why. Can you help us, please? So far as your witness statement is concerned, your recollection or reconstruction of your involvement in the Post Office Limited and Castleton is that this was essentially a Shaw and Picton case, the case of agency.
It was from about the summer of 2006, yes.
But you must accept, I mean, you have read the judgment of His Honour Judge Havery, Queen's Counsel, several times, haven't you?
Yes.
And in fact, you read it because you read it before composing your statement in May of this year.
Yes, I needed to remind myself about what had gone on.
Yes, exactly. And you can see, can you not, from that Mr. Castleton's case put the reliability of the Horizon system fairly and squarely in issue, didn't it? Didn't he?
Mr. Castleton sought to suggest that the losses were illusory and were caused by the Horizon system. At no stage prior to the trial did he articulate or identify how it was that those losses were being occasioned.
But you must have read the call, the Horizon System help desk logs concerning his case and the complaints that he was making contemporaneously, Mr. Morgan, surely?
I would have read them in the trial bundle, yes.
Yes. And you must also it's clear from the judgment itself that beginning at paragraph 12 and proceeding thereafter, 13, 14, 15, etc., he gave detailed accounts of what was going wrong with the system. It's clear in the judgment.
He gave accounts of what he said was going wrong and that he phoned the help desk, and there was a complaint that the help desk wasn't helpful at all, yes.
But also the nature of the glitches, the nature of the anomalies that were occurring. He was
I mean, it feels worse than that, because not only was the help desk not helpful, they promised that they would help him before hanging him out to dry.
Describing them,
Yes.
as it were, in real time.
Yes.
And also how he would take balanced snapshots. In other words, he would take screen grabs of the screen, pictures of the screen, showing how, inexplicably, there were alterations in the figures presented by Horizon. That was also part of his case, wasn't it?
Let me be honest with you here. I don't recall him ever presenting evidence to that effect to the judge. I don't recall that. I'm not saying he didn't do it. I just don't recall that.
You remember when Mr. Beer was reading out part of the transcript just a few moments ago, and I don't necessarily suggest that you ought to have picked it up, but he was referring to balanced snapshots.
Yes.
Now, at paragraph 4 of the judgment, and the judgment is POL 000021678, and I don't suggest that it is put up on screen, but purely as a reference. There is the following. The learned judge stated, losses apparently shown by the balance lists and cash accounts, bracket final, were illusory, not real. It was entirely the product of problems with the Horizon computer and accounting system. The apparent shortfalls were nothing more than accounting errors arising from the operation of the Horizon system. That's what the learned judge said when he was recounting or encapsulating Mr. Castleton's case. You wouldn't disagree with that?
Well, you're reading from the judgment, so no.
Yes. Now, the bias that I suggest is that that was not taken seriously. I don't suggest by you, because you did ask questions. It is clear that you asked questions, including whether Fujitsu could, as it were, interfere with the system or, as it were, have access to the system without Mr. Castleton's knowledge. And you...
Those were the questions that, of course, that we've seen before that he never actually received an answer to and never chased up.
Asked those questions, but can you help us, please? To what extent were those serious concerns followed up by your team? Because, of course, you as counsel were leading your team, weren't you?
I was instructed to appear at trial. Yes. I was instructed to amend the pleadings. Yes. I don't know. I mean, I asked questions. I didn't get answers.
And we know, and I don't ask for it to be put up on screen, but we know from Mr. Castleton's pleadings, LCAS 40294, Mr. Beer has taken you to paragraph 5, paragraph 6, but also paragraph 7b, that Mr. Castleton was vehemently disputing that these losses were real. They were not accurate. They were artifacts of the Horizon system. You don't disagree with that, do you? That's what he was saying.
Yeah. No, I agree.
And that demanded, obviously, the most serious scrutiny, did it not?
That's what a trial is meant to achieve.
But in the run-up to a trial, because of course it's too late sometimes, or too often too late when it arises in a trial, but in the run-up to a trial, there ought to be full and frank disclosure, shouldn't there?
There is disclosure in accordance with the requirements of the CPR, yes.
Yes.